afternoon. Good afternoon. I'm very excited to have this first masterclass of 2022. Can't believe that it's been this long since our last masterclass. And this one, we're going to be talking about employee or contractor. Why would business want control? Before I introduce our excellent panelists, I want to just talk about who I am and acknowledge the country in which I stand. So my name is Greg Dickerson. I am the Managing Director for LexisNexis. And as part of my acknowledgement, it's good to introduce my ancestry as well. So I'm a South African of Dutch, French, Huguenot, and British descent who immigrated to this beautiful land 20 years ago. I stand now on Gamaragal land in Darook country, and I show my respect to the traditional custodians of this land in which I stand, but also on the land in which you stand, of elders past, present, and emerging. And I would like to acknowledge that, and ask you to acknowledge too, that this is a very, to acknowledge country is a very important part of what we do. And it's very hard sometimes in a virtual environment. So it's good for us to take time and also to understand where we stand and also to understand the ancestry that brings us to this point where we are. So we have some very exciting speakers today, and I am very excited about this topic. It's something that I do sometimes talk about at the barbecue, as I was saying to Michael before, because we're all employers or employees. We all have a relationship in which this kind of topic around contracting, etc., is of importance or of interest. So our first speaker is Laura Regan. Laura is the legal counsel and company secretary for Davidson Group, an Australian national company leading in enhancing workplace performance by offering a range of specialist services in business advisory, search and recruitment, and technology consulting. Before her current position, Laura was a senior associate in the national workplace team at Spark Helmore Lawyers and held in-house positions with state government departments and the Queensland Resources Council. Laura has experience pursuing and defending Sham contracting claims and advising on compliance with a range of employment, labour hire licensing, and other regulations when engaging independent contractors. Laura, it's great to have you on the panel.
Thank you.
Our second panelist is Michael Mead. Michael is a partner at Kingston Reid, and he has more than 2 decades of experience advising employers. He is passionate about identifying innovative solutions to complex industrial relations problems. Major national and multinational businesses often seek Michael's insights and advice on resolving challenging issues. As a key advisor and representative for a peak employer industry organization, he has been, which also included 5 years as head of workplace relations, legal and consulting services. He has dealt with employers across an array of industries, including defense, retail, fast food and hospitality, FMCG, manufacturing and aviation ground handling operations. He has also run major industry cases in the manufacturing industry, clerical sector, building and construction industry, food manufacturing sector, and pay equity proceedings for the social and community services sector. He has appeared before an extensive number of full bench proceedings in the Fair Work Commission and was centrally involved on behalf of employers in the award modernisation matters before the Australian Industrial Relations Commission through 2008 to 2010. Michael has also been a member of the Australian Employee Delegation to the International Labour Organization Conference in Geneva in Switzerland in 2010. So he does manage major industrial disputes in highly organised and difficult environments, be it through navigating strategic decisions or through litigation where required. Michael, it's awesome to have you on panel. It's really good to have you here.
Thanks, Greg.
And our final panelist is Jonas Blackmore. Jonas works for LexisNexis as a senior legal writer, focusing on employment. And she was previously a workplace relations specialist lawyer and has more than 10 years experience practicing in the UK and Australia. Jonas was most recently a senior associate at Johnson Winter Stattley in the workplace relations team and published extensively during her time at JWS. She also previously had a role at Sydney for Ashurst and in the UK for Allen and Overy. Jonas, also always good to have you on these panels.
Thanks.
So before we jump into the conversation, I'd like to throw up a polling question to see from the audience where you stand. So Tam, if you could throw up the polling question. The polling question is, the High Court has recently decided that courts will mostly be determining whether a person is an employee or independent contractor by looking at what is written in the contract. Has this changed how you approach your independent contractor arrangements? Now, maybe it's a bit of a furphy of a question, and we all know the answer, but it'll be interesting to see what the audience has to say. And before we jump into the questions, please note that you do have the ability to ask a question yourself under the Q&A. So if you click on the Q&A button at the bottom of your Zoom call, you can throw a question in there. I will start with a few questions and we'll frame up the conversation, but then we'll definitely be looking to the audience to see where the conversation goes. And we can drop that down now. And maybe let's see what the results are. If we can see the results before we jump into the question, I think that'll be good. So that's an interesting split. I thought there'd be more people saying yes, but 58% of people are saying yes. It's changed how they approach independent contract arrangements, and 42% are saying no. It'd be interesting after this, maybe we throw the poll up again and see if after this conversation it changes where people stand. Okay, thank you, Tim. If you can close that. So Jonas, maybe before we even start, can you frame up why are we here today? And we're talking about work status, and it's obviously very topical since the recent High Court decision. But why does it matter?
Well, thanks very much, Greg. And yes, it really is about work status. Essentially, if you're an independent contractor, there's a whole lot of minimum entitlements you do not have. And you do not have access to remedies such as unfair dismissal. An employee has these things. And so the real question that often comes up is a person an employee or a contractor? So before these recent High Court cases, courts decided that by looking at the contract, but also at how the relationship would actually work in practice, you know, what these parties would do when they worked. This approach was and is called a multifactorial analysis or totality approach. Basically, you know, the court takes an impressionistic type approach across the contract and the circumstances of the case and decides, mixing all those things together, what a person's work status will be. But this has now changed, we think, and this is due to these two recent High Court cases that we'll talk about shortly, that have said to us that if you have a clear and comprehensive contract, the only thing that you're going to look at is the terms in that contract. There are some other things that could be relevant if there was sham contracting, if there'd been a contract variation, but the basic position is it's the contract. And it's a contract you take a multifactorial approach to, you look at its terms, and that decides work status. You know, and so I hand over now to Michael. We've got to talk about truck drivers and backpackers now. So I give that over to your capable hands.
Well, thanks very much, Jonas. So yeah, truck drivers and backpackers. I'll be talking a little bit about the truck drivers case, and the truck drivers case is the one that its full name is ZG Operations Pty Ltd and Jamsek and Whitby, but it's been kind of abbreviated in kind of, you know, industrial parlance and in the conversations at water coolers and at barbecues and dinner parties to just be called Jamsek. And the Jamsek case is one of the two High Court judgments that we handed down on the 9th of February dealing with these independent contractor questions. Look, the brief facts for Jamsek, and that'll frame up then our conversation, is that we had two truck drivers, Mr. Jamsek and a Mr. Whitby, who were essentially owner drivers, and they were performing services for the appellant ZG Operations. They'd been performing those services for about 30 years in a capacity as independent contractors. And essentially prior to them setting up those independent contractor arrangements to provide truck driving services to ZG, they had been employees of ZG, but around 1986, ZG, or rather a predecessor entity to ZG, decided that it was going to change the way in which those services were being delivered, and essentially offered to Mr. Jamsek and Mr. Whitby the opportunity to be independent contractors and set up written contracts basically on those terms. So the nature of the arrangement for Jamsek and Whitby essentially were that for almost all of the 30 years, the way they provided those services were through a partnership arrangement. So the structure that they used to first of all establish the contract and then deliver the service was a partnership. And that'll be important in the context of the way in which some of the discussion I think develops today, considering the structures that you might have in place to establish these types of arrangements. But essentially, the partnership structure meant that Jamsek and Whitby were availing themselves of a range of benefits, and essentially what the High Court found was conducting a business. So they paid all of their truck-related costs through the partnership. They received the revenue through the partnership. Things like they rendered tax invoices. They claimed tax benefits as a result of the partnership structure. The partnerships they had were not with each other, but the partnerships were with their respective wives. So they also availed themselves of the benefits of splitting essentially the income derived from providing the service with the other party in their partnership, their wives, even though their wives weren't essentially providing any of those truck driving services. Now, it wound its way through the court system. At first instance, the matter was dismissed by the primary judge, the first instance judge, essentially finding that the nature of the arrangement was one of principal and independent contractor. When it found its way to the full federal court, the full court went in a different direction and essentially, consistent with what Jonas said, applied this multifactorial test, but looked at the way in which essentially the contract had played out over the course of the 30 years and essentially aggregated all of the various circumstances in which the contract had been discharged and said, well, having regard to all of those matters, we believe that what we've got here is an employment relationship, and pointed at things like control and the nature of goodwill that might have been available under the contract, the fact that Jamsek and Whitby only essentially worked for the one principal for an extended period of time. So there are a range of things they looked at in terms of the flavour of the contract over the 30 years to arrive at this conclusion. It gets itself to the High Court, and essentially the really important principle is that the High Court said, well, look, what we've got here is a complete written contract. Everyone who's come to the court, these parties have come to the court and they've all accepted that the written contract is the start and finishing point of the way in which the relationship has been constructed. We'll talk a little bit later, I expect, about things like variation of contract, either orally or by conduct, or sham contracting, and a range of other things that could have been argued but weren't. So essentially the court said, well, in the face of the fact that the parties have come here saying, well, we've got a complete written contract, why should we spend any time looking at the way in which the contract may have played itself out over the 30 years? The court's role is to essentially enforce the legal rights of the parties. And what we think we have here, based on the legal rights as codified in those written contracts, is a relationship of independent contractor and principal. And there we were. So it was a kind of significant day. As I said, they also handed down the personnel contracting matter that I think maybe Laura will pivot to. But the principles were ones that I think extended from some of the conversation and the discussion of the court just 8 months earlier in Workpac and Rosado, that although it wasn't an independent contracting matter, that I expect many of you would know was about casual employment, the nature of casual employment. It picked up on some of those threads in terms of when you've got a complete written agreement, why should the contract not be?
Thanks for that, Michael. Just to pick up on a question in the thing here, is just also noting that we have had a question remitted to the full federal court in terms of whether the partners in this case were actually entitled to have superannuation, and that's something that I'm not quite sure when that's likely to be heard. Do you have any idea on that?
I don't have the details of that.
Yeah, me either.
That issue is all about obviously the extended definition of employee under the superannuation legislation.
Yeah, that's right. Thank you. And Laura, I know you're going to continue now, and just to acknowledge, we've got this question in the chat about a person that might want to be an independent contractor, but actually looks like an employee, and we'll come to that at some point. So handing over to you, Laura.
Thanks, Janice. So the same time the High Court was deciding on the Jamsek case, they were also deciding on another case that's commonly known as personnel contracting, but its full name is Construction, Forestry, Maritime, Mining and Energy Union versus Personnel Contracting. And to provide a brief summary, essentially the High Court applied very similar reasoning, or the same reasoning as what Michael has just gone through, but to very different circumstances. So in this case, we didn't have a partnership business structure. What we had was a 22-year-old backpacker traveling around Australia, unskilled, on a working holiday visa, who approached Personnel Contracting, who were going by the name of Construct, for work. And Construct was in the business of providing labour hire to clients, one of which was Hanson. So Construct offered Mr. McCourt, the 22-year-old backpacker, work under a contract that they called an administrative services contract. And under that contract, he was described as a self-employed contractor. Under that contract, they then placed Mr. McCourt on what a labour hire company might call assignment at 2 Hanson building sites on 2 separate occasions for a relatively brief period of time. I believe they're about 3 months each with a break in between. Now, the administrative, there was no contract between Hanson and Mr. McCourt. The contract was solely between Construct and Hanson as a labour hire agreement, and that did provide that any worker that Construct provided would work under the direction and supervision of Hanson. What the court said was ultimately that wasn't the relevant contract. The contract that they wanted to look at was the administrative service agreement, the contract between Construct and Mr. McCourt. So prior to getting to the High Court, in the first instance, the single judge of the federal court applied the multifactorial test that Jonas has spoken about, and they found that on the balance, Mr. McCourt was a contractor. And then the full bench of the federal court agreed. However, they noted that they felt bound by another case that had been heard with the same parties and the same contracting arrangement, where a court had found that it was contracting and they couldn't find any obvious error in that decision. So when it got to the High Court, as Michael has flagged, focused on the fact that there was a comprehensive written agreement. And what they said is that where parties have comprehensively committed the terms and obligations between them to a written contract, then it's not appropriate to look at the other circumstances. It's not appropriate to look at the subsequent conduct of the parties, that the court can and should determine the nature of the relationship by solely looking at the terms of that contract. And when they did that, what the majority, so 6 out of 7 judges, although there was a few different written decisions, what they found was that because the contract allowed for a degree of control over the work that Mr. McCourt was doing, because it provided that he, for instance, must cooperate with Hanson in the provision of his labour, and as such was essentially required to provide compliant services, and that Construct had a right to dictate who Mr. McCourt worked for, that characterised the contract as one of employment, despite the fact that it did actually say he was engaged as a contractor.
I think that's really an important point there now too, Laura, that while we're looking at the terms of the contract now, just because the contract describes what the relationship is, that's really not going to be influential here. What will be influential is the whole variety of terms in the contract. And I guess one real difference we've got here is we had this interposed, entity, the partnership arrangement with the trucks, but we didn't have anything like that with the backpacker. And it seems like that factor may be something that is relevant in the way people approach these things in the future. Sorry.
So Jonas, that's fine. I was just going to throw the question then to Laura, the anonymous attendee question, which is, so what is the position where you have a worker who on all indications is clearly an employee, but despite that, it's just being treated as an independent contractor? I think you've answered that, but I'll just throw that question to you.
And not obviously your own organisation, Laura, here, just
Yes,
speaking more generally.
I think that's a great question, because from a practical perspective, you do get people who say, I only want to do this work under these certain circumstances. But I think that what these cases show us is that whereas perhaps you might have been able to submit evidence to a court about the intention of the parties and the requests of the person, that ultimately all of those other factors aren't going to be as significant as what the contract says. Itself.
Yeah, so you've got to make sure that the contract itself is framed up, that there's sufficient terms that make that clear that they're an independent contractor.
Yeah, and that being said, I think Michael mentioned this and I forgot to mention in this, is that the court did stress in personnel contracting as well, that it's sure it will look at the contract so long as it's not a sham or obviously invalid. So,
Yeah.
You know, there's no point entering a contract because someone says, I want it to be on those terms. If those terms are so abhorrent to reality or, you know, have been varied by conduct, etc., that contract's going to be considered a sham anyway, in which case you go back to actually looking at the circumstances, the contract. If the contract is a sham or it is considered invalid, then the court's going to go back and look at the circumstances, in which case perhaps, you know, that consideration of what's really going on as opposed to just because someone wanted to be an independent contractor might sway a court in favour of them being genuine employee.
Yeah.
And can I just also add the anonymous question? I think absolutely I agree with Laura insofar as the risks in and around sham. I think you know, we're going to talk a little bit about sham contracting, I think, or sham arrangements over the course of today's discussion. The High Court judgments do talk about sham as a concept, as a basis upon which, well, no party brought that argument to the court, so we're not going to rule on that. But, you know, the anonymous question here, which essentially strikes at, we all know it's an employment arrangement. We want to have an employment arrangement, but the employee wants it to be badged as an independent contractor arrangement. I think that has a range of risks, you know, not least of which the Section 357 provisions of the Fair Work Act that deal with kind of knowingly or recklessly misrepresenting the nature of a arrangement as one of a contracting arrangement when in fact it's an employment arrangement. So, you know, I think if you're facing into a situation like this, I think you've got to give consideration to what's the type of structure that we're entering into, what's the parties that might be entering into it in terms of, you know, is it going to be with an entity, a partnership that might allow you to then step one step further from the risks associated with it being couched as a employment arrangement. And then, you know, I think to Laura's point, what are the actual substantive terms that we're going to have in this arrangement that go to questions of you know, control and those multifactorial indicia that need to be considered in the context of characterising the written terms of the contract.
So, Michael, I mean, from a law firm perspective, what are your clients saying? I mean, what do you see in the reaction in the market as a result of these two decisions?
Yeah, look, it's a good question, Greg. I think it's interesting the survey response that, you know, a little over kind of half indicated that the decisions had motivated them to rethink their contracts. We were finding that a significantly higher proportion of our clients have at least asked us to review the terms of their contracts. And I think there's a range of things that kind of fold into that. I think obviously where various clients and businesses might be in their own consideration of these issues, you know, the nature of the multifactorial test hasn't really been shifted in terms of considering how it's brought to bear on issues like dominant control of the you know, contractor / worker. What the Jamsek and personnel contracting matters really do is where you've got a complete written contract, as we've already said, not permit an inquiry into how the contract plays out in practice, but instead looking at the substantive terms. But we've had a lot of work in terms of reshaping and reviewing contracts to pick up things like you know, ensuring that, you know, the way in which contracts might be varied can only be by subsequent written agreement. So to try and remove risks of arguments that weren't running Jamsek and personnel contracting about variation of the contract orally or by conduct. So, you know, you can shore up some of your approach that way. So yeah, look, we found an uptick in that kind of work, and we're happy to receive it.
And Michael, I think also on those terms, then you have mentioned before that having an entire agreement clause is very important, because while the courts won't consider the post-contractual conduct, they will otherwise consider the conduct around the time that contract is formed. And therefore, if there's any representations or other documents outside the contract itself, and you don't have an entire agreement clause, then you risk, you know, more circumstances being taken into account than what you might want. Is that the case?
Yes, I think that's absolutely right. So I think ultimately your risk mitigation strategy is to rely on the written terms of the contract and the security that provides you, and have reviewed and redrafted them in a way that is coherent to a independent contractor arrangement, then having an entire agreement proposition within it, and also, as I said, those mitigation steps in and around how the instrument might be varied, allow you to run a more robust argument, should it ever be challenged, that this written contract is the complete statement of agreement between the parties, and the contract is king.
Or queen. And Laura,
Contract is royalty.
Yeah, that's right. And so Laura, like as a client in the hot seat, like, sweating away, although you're not only looking very fabulous there, but, you obviously have your own house in order. So we're not talking about your own, position here in your own business, but do you think the High Court has sort of provided certainty here for employers in how to set up these relationships with their workers?
I think they've taken that great first step, like they did in Rosado, where they've given us a basis for certainty and a basis to start working towards certainty. I think they've also created a decent amount of work for lawyers in terms of how you get to that certainty. I think what they've done is they've reaffirmed that traditional idea that if parties voluntarily and consciously sit down and agree to the terms upon which they're going to engage with each other, short of various circumstances, they should be able to rely on that. And certainty is great for companies. You want certainty. You want to understand where your risk is. That being said, the good lawyer said there's always a caveat. I still think there's T's to be crossed and I's to be dotted, especially when you drill down to that practical day-to-day questions. It's fine to say review your contracts, but as you start to potentially review those contracts, not every contracting relationship is the same. They can vary. There's a lot of commercial considerations that everyone is going to have to start considering in the context. Right, is this issue in control? Is this starting to be a flavour of employment, or is this a legitimate commercial obligation associated with what the services are, as opposed to how the services are going to be carried out? So there's certainly still, I still think there'll be cases before the court to nut out some of the finer intricacies of those terms and obligations within the contracts.
Oh, that's great. I think, it's really interesting what you've talked about there. Like, what are these terms? And I wonder if I could hand that over to you, Michael, to sort of talk about some of the nitty-gritties here. Like, we've got our, scope sort of provisions of the entire agreement and variation that sets the scene so we can make sure that no further conduct happens. But what about if, for example, the host client contractor or whatever wants to subcontract it, but they want to protect their IP, or they want to restrain that contractor from going off and doing some sort of competing business. What sort of issues are going to come in here with these terms, taking that kind of commercial view of what actually businesses might be trying to achieve here, and of course workers?
Yeah, look, once again, a really good question. So what the two High Court judgments don't do is give us a shopping list of clauses that can go in and clauses that can't go in a contract. So what they do say unequivocally is, I don't really care what the label is that the parties give to the contract. So to you, I think you said this earlier, Jonas, the court's view was it's our job to interpret the law, and what the parties to the contract might think they've created is not the right inquiry. They use in both judgments, and it was, I think, a function also of the submissions that were made by senior counsel in the proceedings, as a proxy for this idea of whether you've got an employment relationship or an independent contractor relationship, the idea of whether the worker was working in their own business or in the business of the party engaging them. And in personal contracting, they say, look, whilst that doesn't substitute for the primary test, that is, we need to always be conscious of, do we have an employment relationship here? Trying to frame up the consideration by this context of whose business is the worker really working in is a really useful way of creating a focal point for some of the considerations and issues. Now, why do I say that? I think to pick up on the fact that we don't have any absolutes here, and there can be a question of nuance and degree. In the Jamsek matter, the contract that was present there had some presumptions about the nature of the engagement that the independent contractors would work. So essentially it was expected that they would work 9 hours a day, 5 days a week for ZG. There was also a provision in the contract that essentially said, well, look, if you're going to get another driver to come and perform these services, that can't be done without our consent and our agreement as to who that individual might be. Similarly, there was also a question about whether there was actually any goodwill in this contract at all, given the fact that it was just for one client, as opposed to these operators providing their services en masse because of the requirements in and around the volume of work they were getting from their single client.
And I think they wore uniforms as well, didn't they, Michael? Which is something that in the past that we would have said, look, on a circumstance of the case, you shouldn't be telling people to wear uniforms. But in this case, the High Court said, well, that's actually an okay thing to do.
Yeah, and I think they also had emblazoned across the vehicles the logos of ZG Operations, so they were branded ZG. Now, why do I raise all those things? Because some of those things, to your point, Jonas, would almost intuitively seem to run contrary to the idea of this being an independent contractor arrangement. So if I'm not allowed to pick someone to subcontract the work to without the principal's consent, do I really have a business, or am I working within the business of the principal? Now, the High Court said on that particular point, well, the fact that there might be a requirement for consent is just the way that the principal ensures that their goods will travel safely from point A to point B. And there were other factors that clearly weighed in the court's mind going in around the fact that we've got these big trucks that are being used as part of the contractual arrangement to deliver the service, and all of those taxation and structural issues in around who might have been party to the contract that really drove the outcome. So where does that take us on things like intellectual property clauses or restraint of trade provisions? Both would seem to intuitively be closer to limitations that preclude you from running your own business, and therefore might be things that, when the contract is assessed, in my view, in totality, that lend itself to a conclusion that you might have a relationship that's not an independent contractor arrangement, but it's not, as I said earlier, an absolute. So the commercial calculus that we're speaking to clients about is what are those commercial interests that you're trying to protect? What is the risk associated with the absence of that protection, as against the risk associated with cohort of independent contractors being regarded then as employees, and all of the liabilities that might flow from that in terms of Fair Work Act entitlements and the like.
It goes, yeah, that does, absolutely does, Michael. It goes to one of the questions we've got through from Richard Stewart, which seems it's a fairly fundamental change in the law, in the same way that Babu was, with the actual performance issue test applied. So do you understand why is the High Court taken this fundamental shift in approach? And I mean, for me, just paraphrasing what you just said, looks like there's a number of clauses you can put in a contract which take you closer or further away from the line of control, essentially, as to whether you're working in your own business or working for whoever I'm talking from the perspective of the contractor or the hiring business. And really, this comes down to your risk perspective of how close you want to get to. So there's a lot more laws we're going to uncover over the next couple of years as this gets tested. But it does seem like the High Court itself has shifted the entire approach. And do we have sort of insights as to why they've done that?
So it's an interesting observation. I think, not to interpose myself as a member of the High Court, but I think we'll probably say we've applied a classical approach to the way in which contracts should be applied and interpreted. So judgments like Varbu, Stevens and Broadbrill, particularly in the personnel contracting judgment, they looked at that. They looked at all of the authority in and around construction of contract. And I'm paraphrasing, but essentially the upshot of their judgment is that anyone who interprets those historical decisions as saying that we shouldn't give primacy to a complete written contract as the source of entitlement or the source of characterisation isn't reading those earlier judgments correctly. And we'll read them correctly now, similar to the way in which they engaged with, I think, Personnel Contracting 1 law. They said in Personnel Contracting 1, whilst there might be similar factual circumstances, unfortunately, they just got the legal position wrong, with the greatest respect to those who handed down that earlier judgment. And so to the ODCO judgment as well, they said, well, the legal position is clear, at least in Personnel Contracting number 1 and ODCO, don't place the label above the features of the contract. And that, in their estimation, is just applying a classical construction to contract law principle, not doing anything way out and creative.
Yeah, I think, we have this essential problem here where we have like, what the business commercially is trying to achieve and what the law says. So what do you think about this, Laura? Like, given we have these two key aspects the courts are looking at, and one is right of control and the other one is the contractor running their own business. Like, when do you think, the issue of a control from the commercial perspective is important?
Well, I think businesses these days are subject to a huge amount of regulations. So there's going to need to be a consideration of what needs to be transcribed into a contract and what you can just rely on statutory obligations. A lot of the statutes on businesses say that businesses need to make sure their supply chains are also compliant. So that's going to affect what's in the contract. But I think Michael hit it quite well when he said there's, at this stage, while we wait for some further determinations, it's a little bit of a risk balancing exercise. You've got you'll have some really obvious commercial risks that you might want to address in the contract. But if by addressing them, you're creating an employment relationship, which isn't the intention of the parties and isn't the true nature of what you're trying to do, then you're perhaps better dealing with those commercial issues outside of the contract or separate to the contract than trying to prescribe every little commercial nuance in a contractual document.
Thanks. And actually, sorry, Greg, you go.
I was just going to jump in because it's a really interesting counter comment from Richard. So I might just bring that up because he's sort of agreeing, obviously, with your answer, Michael, and yours, Laura, but he was also asking, how does this go to the special power imbalance, the regulation around that? Because, as you know, the employee-employee relationship is not always one of equal power, and hence the reason why contracts and the interpretation of behaviour post-contract has been part of the law.
Yeah, so it's a good question, Richard. I think there are some comments, that I can't recall if it's in Jamsek or Personnel, in and around, once again, how the case was run, and that there wasn't any representations made about there being a particular power imbalance in the formation of the contract such that it would undermine the court's interpretation of the express terms. So there was no arguments run about contracts formed under coercion or duress or with any specific power imbalance that might vitiate the express terms of the contract. But you are right. I think there can be power imbalance between bargaining parties when contracts are struck. It does potentially touch on where maybe the litigation goes in this area. And I'm not sure, many of you may be familiar that there's a Federal Independent Contractors Act that applies. It was passed in 2006. It's been a bit of a non-starter in terms of seeking to address circumstances of unfairness, essentially in independent contractor arrangements. But there may be some fertile ground in and around that area. So that legislation wouldn't, in my view, have the ability to change the fundamental character of the contract. So it couldn't allow the court to turn the independent contractor contract into an employment contract. but it does give the court the ability, if there is unfairness or harshness in the terms of the contract, to issue orders to set aside or vary the substantive terms of the contract. And one of the considerations the court can look at is whether in fact those under the independent contractor arrangement are receiving conditions that are less than they would have received had they been employees. So it's not something that got a start in Jamsek and Personnel, because those matters weren't litigated in the context of pleading that statutory remedy. But there has been some discussion already about whether in fact that's the new frontier for complete written contracts that are independent contractor arrangements and can't get around the High Court's reasoning, whether they instead will be pled under proceedings through that independent contractors legislation.
Right.
I can see some talk in the chat. Thanks, Ronan and Declan, for your comments. Really, I hesitate to call double dipping, because obviously that has other connotations. But, you know, one of the real concerns is if you have a situation and, you know, a contractor arrangement has been put in place, but it is then found obviously to be an employee relationship. I don't think that there's anything you can really do to provide any offsetting. Like, it's not a case where you can have a loading, that we now have that sort of underlying statute providing a basis for offsetting. It's not a case where you might, you know, have an annualized salary and you'll have an offset clause saying that your money you're paying an employee in that situation covers off on award entitlements. Like, is there anything that you can do in the contract that would provide for the opportunity to sort of, you know, offset any later monetary liabilities that could come up with underpayment of entitlements?
Yeah, so I don't think it is. I think you're stuck, and you're right. You know, it's like in the casual context, we now have, as a result of legislative amendment, the ability to essentially set off, or for the court to essentially take into account things like a casual loading in addressing any claims that an employee might make who was believed to be casual, but in the final wash-up is found not to be. So, you know, kind of a statutory regime to be able to set off and insulate employers from those mistakes. In the independent contractor space, if essentially what we have is an employment relationship and not an independent contractor one, then all of those safety net entitlements, like the NS entitlements, like an entitlement to a minimum rate of pay under the award, hours of work, all of those are part of a statutory safety net that couldn't be contracted out of anyway. So that's where the big risk sits, and probably in my mind why it's sensible to try to shore up your independent contractor arrangements with the benefit of these judgments, to try and make sure that you've got you know, as much security as possible against those claims darkening your doorstep.
Yeah.
So then it might be talking about casual. It might be worth throwing to you, Laura. Do you think now it actually makes casual employment offer potentially a better option or a good option? Obviously, there's still some decisions in front of the High Court at the moment on the definition of a casual employment as well.
I think it will depend. I think when you're faced with a situation where perhaps the work you're looking at engaging someone for could well and truly suit a contracting arrangement, but that person who you potentially want to engage is not running their own independent business and can't meet your internal thresholds for establishing that they are genuinely running their own business, that would be a better option from a risk perspective than trying to make them you know, comply with that contracting relationship. But, you know, I think ultimately there's a number of ways to get a job done or get work performed. And the first question is always going to be, well, what do I need done and how do I need to influence that? Is it something that I'm going to need to direct and control? Or is it something that I need a specialist independent person to come in as a genuine contractor and do that work for me? And in some cases where you can't, you know, you can't put a square peg in a round hole, then a casual employment relationship might be the better way to go about it.
It seems like it would be nice if there were some changes in the Fair Work Act that provide some statutory guidance on the terms that you put in the contract. Would find that a useful thing, Laura? Assuming
I think
that could
after
be
Rosada,
done.
that was look, if it can be done, absolutely. I think the changes that resulted from some of the earlier Rosada decisions were of great benefit to the private sector, and just providing that surety and that really clear statutory guidance of, if you meet these 4 factors, are you offering casual loading? Are you calling them a casual? Are you treating them like a casual, as per all those steps? If there's something equivalent, certainty is amazing. The more certainty, the better, rather than allowing an opportunity for things to be constantly questioned and grey areas and challenged.
And whilst not wishing to get political, obviously we're facing a federal election, and
That's right.
I know that the opposition's policy is very much focused from a workplace relations perspective in and around reducing insecure work, and they place not only casual employees but contractor arrangements and rolling fixed term arrangements as part of this whole banner of insecure work, including gig workers. So if there were to be a change in government, I expect we're not going to get the kind of certainty, at least, that lines up with Jamsek and Personnel. You might find yourself with a very different legislative framework that you're dealing with.
Yeah, I guess I probably should jump in. It depends on what the legislative framework says, Joe. I'm sure the private sector would very much like to also continue to have the freedom to engage in commercially productive manners and not feel hamstrung, but being forced to engage people in certain ways when it doesn't always apply and work in practice.
Actually, so Michael, I'm curious then what you do or what you'd recommend, and it may depend on the circumstances, to a client who comes in and says, hey, I've got these really great independent contractor arrangements here, they're really protecting me, and you look at them and you go, I think these look very employee-like. What are next steps then in that situation?
Yeah, so I think if the instructions are that they want to have the independent contractor arrangement, it's of benefit to them, and the independent contractors want to continue in that vein, then it's a matter of, well, how do we try to create a variation to that arrangement to give effect to a more secure footing for that engagement. One of the things that I think is quite important, if it can be achieved, is looking clearly at the structure of the contracting parties. So the partnership arrangement, the nature of that partnership arrangement in Jamsek was a really important factor that the court chewed over at some length in ultimately arriving at a conclusion that we had a legitimate business that was being carried on here by Mr. Jamsek and Whitby. So in looking to reframe an independent contractor arrangement that smells a bit fishy in the appropriate way, I would start there, and then I would build out from that point in terms of trying to understand what the degree of control is that you might actually need to exert on this worker in order to get your commercial outcomes. If it turns out that the degree of control and we can't get the right, corporate structure in place, for want of a better phrase, and we need to face into the fact that we've got an employment arrangement here that is more likely to be what's going to be found, then I think a sensible place to start is to conversation in around casual employment, as Laura's indicated. A lot of the features of and flexibilities that are beneficial to, I think, parties when they're thinking about independent contractor arrangements are similarly a feature of the casual employment arrangement. You've got the ability to understand the rate of pay and not have accruing liabilities that might impact you, the impact of the cost of public holidays, albeit they're all built into the casually loaded rate. Just as a kind of commercial proposition, it's dollars in, dollars out from a commercial outcome perspective. But of course, in seeking to then enact those varied arrangements, you've got to make sure that you can actually get agreement with the party you're contracting with to try to shore up your patch.
So in that respect, Michael, hopefully you've had a good conversation then with this other, person, and they've agreed to take it forward and have some more certain contractor arrangements in place. Do you have to make sure that the point before entering this new arrangement is clear, that the previous arrangement has ended?
Yeah. Yeah, well, I think we had that discussion a little bit, at least tangentially. The terms of the contract that you'll enter into will have, hopefully propositions, if you're sensible, that talk about the terms of this agreement replacing any prior agreement that may have been entered into between the parties, and then those other terms in and around it being an exhaustive agreement and the restrictions on variation that we also spoke about. Those are all, I think, really sensible features of a contract that you're trying to minimise risk under the terms of.
And would you need something in it? And just putting an employer hat on here, not because I'm just focused on employers, but would you need something in it, in that new contract, or something separate to that, explicitly terminating the previous arrangement?
Look, I think that's potentially an option, but I don't necessarily need to get there if the way in which you've structured the terms of the replacement contract are such that it becomes a variation and overrides or extinguishes any previous agreements or variations that have been entered into. So I think
just be thoughtful about what you're trying to achieve. You don't need to flag all these additional things. You can make that a nice smooth transition between arrangements if everyone's green.
There's a question that's come up in the chat, which we have talked about sham contracting tangentially, but it might be worth just sort of addressing sham contracting for a minute or two, and maybe throw this to you, Laura. So the question is, in the context of labour hire arrangements, how can an aggrieved independent contractor seek recourse against the principal for engaging in sham contracting?
Sorry, can you just say that again, Greg?
Sorry, in the context of labour hire arrangements, how can an aggrieved independent contractor seek recourse against the principal for engaging in sham contracting? So,
can an aggrieved worker seek recourse against their principal?
The principal, yeah.
Absolutely. I mean, under the sham contracting legislation, there's generally a degree of recklessness or negligence, which I would like to think most reputable labour hire companies have passed.
Exactly. Yeah.
There's enough case law now and enough, we're far down that track now that you would hope that most reputable companies have established, that they're not reckless and they're not negligent to when they enter into those agreements. But if they are, then absolutely that's open to them.
And I think that's the point, really, is that the High Court decision does not change the fact that you can't engage in sham contracting. That is completely outside the scope. Yeah, that's right.
And I think, Greg, the other point is that, knowingly or recklessly is kind of the threshold for the 357 mitigation. It's a pretty narrow laneway, in my view, although that laneway may have opened up a little bit, given the fact that if you're going to continue to rely on the type of tripartite contractor arrangements that were a feature of Personnel 1, Personnel 2 and ODCO, and now without kind of any recognition of the way in which the High Court has reframed an interpretation of those tripart arrangements, just continue to barrel down that freeway, you might be recklessly engaging in it in conduct that amounts to a sham arrangement. So perhaps the risk profile has moved just slightly north as a result of these decisions. If what you're going to do as a labour hire provider is continue just to do the same thing we were always doing.
And actually, I think probably it's important at this point as well, you don't always have a clear contract in place. And so when you don't have one of those clear and comprehensive contracts, then we fall back to looking at all the circumstances of the case, or determining whether there's an oral based contract here, do we not? In which case, all of this kind of goes out the window, because it actually matters how it's working in practice.
Yeah, that's right. So I think if we don't have a clear written contract, then we are potentially going uphill and down dale to look at, oral representations and conduct-based representations to try to identify, well, what were the substantive terms of the deal that were entered into between the parties, and obviously that involves offer and acceptance, consideration, and intention of form, a legal relationship, all the kind of principles of classic contract law. But in the absence of a written agreement, it becomes a far murkier and more involved process where a party, I think, asserting the nature of the the nature of the contract should be something different to what you're asserting, can rely on all of those, conduct or oral representations to try to change the parameters.
So really, yes, you want to get this great contract in place, but you also actually want to run it like, in a manner that's consistent, just in case you don't have the contract you think you have, and the court needs to go and actually look outside that. Yeah. If you have a half contract or no contract, you can't really just rest on your laurels.
Yeah, I think that's exactly right.
Yeah. So I'm sure, like Laura, and I know we're nearing the end here, and Greg, keep me on the head if I'm talking too much. Do you guys have any top tips to share with us out here? I'd be very, very interested to hear from you both.
Well, I think we've got 4 minutes, and I think it's a perfect ending question. So maybe 2 minutes each on top tips. So do you want to go first, Laura? No one's putting their hand up. So like the teacher, I have nominated you.
I think I'll just capture that last point of Michael in terms of we've got a bit more knowledge now. So we're going to use that knowledge to apply it to our contracts, continue to review, continue to assess. And that's going to be the least risky way forward.
Yeah, and for mine, at the risk of being repetitive and overlapping with Laura, I think it's notwithstanding that there were views that were basically 50-50 split on whether people were motivated to review their contracts as a result of Jamsek and Personnel. I really can't think of a good reason why you wouldn't do that. I think the court has given us some signposting and to minimise your risk and to lower the chances of finding yourself in some deep water that is unfortunate. Getting someone to review those contracts and spending the time to do it yourself, having regard to kind of some of those matters and the multi-factor indicia that were reflected in those two decisions is a sensible and good use of your time.
Great.
Well, thank you. You took 2 minutes shorter than I thought, but I think that's good. We'll give everybody a rest break before their next meetings. I'm sure at 1. So thank you very much, Michael and Laura. It's awesome to have you on. I think we could have gone for another hour of conversation, and there's probably lots of other areas we could explore. But that was a very, very interesting and comprehensive hour. So thank you so much. Thank you, Jonas, too. And to our audience, thank you for coming on. We had a large number of participants, which is great to see. And hope you have a great rest of the day. Thank you.
Great. Thanks, everyone.
Thank you.
Okay, bye.